it's my pleasure to introduce our opening speaker, Jennifer Hoffman, who is Commissioner for Victims of Crime with the Department of the Attorney General, Western Australia. Jennifer Hoffman was appointed to the position of inaugural Commissioner for Victims of Crime for Western Australia in July of 2013. The role of Commissioner was announced by the Attorney General as part of a range of enhanced supports for victims of crime, which included substantial additional funding for victim support services. The Commissioner provides high-level advice to the Director General of the Department of the Attorney General, Ms. Cheryl Gwilliam, and to the Attorney General, the Honourable Michael Mission, MLC, on issues surrounding victims of crime in WA, and advocates across government for coordinated victim of crime policies and services. The Commissioner is also responsible for ensuring that members of the public and government agencies are aware of the rights and responsibilities in the Victims of Crime Act 1994. She consults widely and on a regular basis with victims of crime and the many agencies and groups that victims find themselves interacting with in order to identify and promote systemic improvements. She is also chair of the Victims of Crime Reference Group, which provides advice to the Attorney General on victim of crime issues. This morning's address is entitled Focusing on Risk, Victims and Criminal Justice Responsiveness. Can we please welcome Jennifer Hoffman to the stage, please?
Well, good morning. Good morning, everyone. Thank you for that, Rick. Much appreciated. Before we get going today, I just wanted to comment on just the quality of the program, the organisation of the last few days. Obviously, it's just highlight upon highlight, and I really do want to acknowledge the outstanding work of the organisers in bringing all of this together. It's a real treat. So this morning I wanted to have a chat to you about issues around focusing on risk in terms of victims, so criminal justice focusing on risk. But before I do that, of course, I do want to acknowledge the traditional owners, Noongar people of the land we're on today, and it's NAIDOC week, which is a very important week to do that. So my opening thought today is to note that the theme of theme that's echoed through the last few days is that we shouldn't presume or prejudge what needs any given victim of crime might have. And also, to me, a theme that's come through is that the evidence isn't mature yet about the extent to which our victim of crime offerings in our many and various jurisdictions actually match up with actual victim needs. But I think that's a terrific insight, and it's one I think that what it means is we mustn't, of course, stop innovating and stop trying, but I think it's a clarion call to all of us to make sure that we are doing the most important task, I think, of public policy, which is evaluation. We must try and understand what it is that we're doing when we're doing it, and we must build in capacity to be nimble and flexible in our program initiatives, and hopefully if we're evaluating and assessing in real time, we've got enough scope to test and reset as we progress with our particular policy programs. I think that is the new world order of public policy probably of the last decade, is this awareness of evaluation being core to every stage of the policy process. Anyway, there endeth my public policy lesson. Now, one type of victim need, though, that we do, it's very clear that there is, and it's different for each victim, but one type of need is the need for protection. So this protection's from future or ongoing victimisation, and or to minimise the anxiety that future or ongoing victimisation may occur for that victim. In this jurisdiction, Western Australia, the Victims of Crime Act 1994 provides 12 guidelines which aim to provide protection and support to victims of crime. The guidelines apply to all state government agencies and staff, and victims have a right to complain if these guidelines aren't met. Now, Guideline 3 of the Victims of Crime Act is the formal recognition that victims do have a need for lawful protection against violence and intimidation. So some of the ways this is made real in this jurisdiction is that, of course, you can ask for a police response if, as a victim, you're feeling that you need police assistance. You can seek assistance through various services to perhaps obtain a violence restraining order. In some types of criminal matters, the court itself does have capacity, in fact must, make a lifetime restraining order or to cover you if that's something that's suitable. So there's some of the ways that we formally deal with this issue of victims needing protection. Other guidelines in the Victims of Crime Act, these are guidelines 10, 11 and 12, relate to victims being able to have their views and concerns considered when a decision is being made about whether the offender should be released from custody. So that's on supervised release or parole. So there's government service providers, including the Victim Offender Mediation Unit in our Department of Corrective Services. They can help victims to request, say, tailored conditions in the parole or supervised release orders. For instance, don't be in contact with the victim or do not approach, those sorts of conditions. So that's another way protection of the victim can be made real. And an initiative of this office as well, my office is Commissioner for Victims of Crime, that the Attorney touched on the other morning when he spoke to us, is we've been trying to work to provide more victim information to parole authorities because we know that it is important to ongoing protection of the community and any victim or victims of the crime itself, but also it's about protection of future potential victims in the community, unfortunately, that when release authorities are considering issues about release of offenders, that they have an understanding of the circumstances of the crime from the victim's point of view. So that's another way that we're certainly looking at this issue about victim protection. However, my view is that there's an increasing citizen expectation, in Australia at least, and I'm sure it's the same elsewhere, of governments and the justice system in particular, protecting victims from either known or what I'm going to call today should have known risks. So who are these people who government should be protecting from these known or government should have known risks? Well, they're the people who've already experienced victimisation, perhaps from the offender, people who are currently experiencing it, and I talk here in particular about the current high profile of the agenda on protection of family violence victims, and also future victims at large. And one of the ways this is being made real is that there's the increasing appetite, I think, both within the community and also, I would say, within politics generally, of post-sentence risk management of offenders. And in this jurisdiction, that's made real in our dangerous sexual offenders legislation, where sexual offenders can be continue to be under supervision, including in custody, post the end of their sentence because of the risk they pose to the community. And the government also has an election policy that will be made real in this term, I'm sure, about providing new legislative capacity to supervise certain violent offenders for up to 2 years after their sentence has issued, in kind of a parole capacity, if you like. But it's another example. It's tied towards the justice system being required to think about risk. Now, recent government announcements in WA regarding family violence reforms have at their core this concept of the expectation that justice is managing risk. So in March this year, the the government announced that there'd be an overhaul of our Civil Restraining Order Protection Act, which is our Violence Restraining Order Act. And what is going to be enacted is what it was announced was going to be enacted was the introduction of new family violence restraining orders, or FVROs. These will be quite specific restraining orders that will have a definition that we hope is better tailored to our modern understanding of the nature and syndrome of family violence. They'll move away from the concept of the victim having to provide evidence of an act of abuse, and they'll be moving toward the decision maker having to be satisfied that the behaviour of the alleged perpetrator is intending to intimidate, coerce or control the victim. One of the new facets of this in the legislation, we imagine will be there, is that courts are going to be required to adopt a risk management approach to granting these FVROs. So there'll be legislative provisions that really make it clear that courts, particularly at the interim stage, must consider evidence of risk, particularly that provided by public agencies like WA Police or Department of Corrective Services or Department for Child Protection and Family Support. So the court must take into account this information regarding a risk. Now, it might be risk-relevant information. For instance, if there have been domestic violence incident reports made to the police, or if there are notifications about the family and the child protection space, or it might even be formal risk assessment information that's been prepared by public sector agencies. Now, we, at the same time, the government's recently announced that right at this minute, building a new court model of dealing with restraining order breaches and serious assaults which occur in a family violence setting. So there'll be a new court listing approach in our magistrates court. So what's happening with this is that police, child protection officers and corrective services office will be on hand to share what they know about the circumstances that led to the charges the charges before the court of breaches of restraining orders or the serious assaults, in order that they might shed light on risks to victims and other things that might need to inform the court decision making. So magistrates court in the launch locations for these lists are going to rearrange their case listings so that these particular criminal charges in relation to family violence will be heard on a designated day each week to ensure that we can cluster victim support and these other agency folks around the list. This new model is replacing an old model of family violence court listing, which was more offender focused, which the evaluations had been shown weren't achieving, I think, what the government had hoped they would. So the new model is very much about offenders and victims, and probably the key difference though is this emphasis on growing pathways to make sure that the integrated service providers in government, who are getting much better at information sharing and integrating their practice with each other, have a clear pathway to get that information to court, so decision makers like magistrates, particularly with matters like protection orders and breaches of protection orders, have a full picture of what's going on. And this is that issue about should have known risk. You know, we know the general public are very frustrated, as indeed I think we are all individually, when something happens to a person who's approached the courts for their assistance, has approached the courts for a restraining order, didn't get the restraining order, something dreadful happens, and it comes out that, you know, there were 15 DV incident reports with the police, for instance. And the general public and we ourselves, I think, can't help but think, well, the court should have known. about that risk. So this is really what's core to these new arrangements in both the proposed legislation and the court model. It's about getting that should have known to decision makers best we can. But it's important to note that the language I've been using this morning about getting this information to court through these information pathways, they're still growing. We know that family violence risk assessment frameworks, including the very good common risk assessment frameworks that can be used across various service providers, so they're working off a common base around risk assessment. We know these are still fairly emergent. I note in New South Wales, for instance, the police force there just this week commencing what they envisage will be a 3-year rollout of a new common risk assessment tool for domestic violence. It's called the DVSAT, Domestic Violence Safety Assessment Tool. So as I say, some of this is still very emergent. So we're still identifying even different forms of risk-relevant information within government regarding family violence. So we're still scratching the surface really of the formal risk assessment tools and processes and embedding them even within agencies, never mind in the cross-agency space. And we're still finding different bits of information that governments and service providers hold that might be relevant to get to, say, a court decision maker to inform them about potential risk of family violence. Now, my view is that the fact that these systems aren't completely mature yet shouldn't stop us from innovating and growing these pathways, these information pathways, to get to court. Because the systems are still maturing though, what is important is that we have terrific governance of the information pathways, because as I say, it's still emergent and it's not going to be perfect. So we've got to have terrific governance to make sure that we are conscious of what's going into those pathways. And then I go back to my opening comments, which is that there's probably 3 incredibly important things that we do around these information pathways, and they are evaluate, evaluate and evaluate. Again, we've got to make sure that we are aware of what we're doing in real time, and that allows us to test and reset and hopefully improve as we go along. But citizens' expectations are clearly that if we should have known, then we should try to know. And that means growing our capacity to share risk-relevant information amongst government and government-funded service providers, and having good frameworks in place to understand the quality of that information. Now, I note that the current New South Wales Police Force rollout of their Domestic Violence Safety Assessment tool notes a range of expected benefits from this new common risk assessment around family violence. And some of these are that they think it will allow for consistency across the police to identify a level of threat of future harm. They think it will allow for increased information exchange between government agencies because they'll be working off a common risk platform. They think it will allow for improved agency accountability to ensure that other agencies are playing their part in assisting and supporting victims of family violence. And they also expect it to reduce re-victimisation. They've said that the experience of international and Australian jurisdictions that use similar DV risk assessment tools is that victims have been less likely to be re-victimised because of increased support offerings to them and increased information available for agencies in order to make informed decisions. Now, of course, that reference to agencies in this jurisdiction, as I've been explaining this morning, will hopefully increasingly include courts. Now, I'm pleased to be able to report that the development and use of common risk assessment tools for family violence has been in place in this jurisdiction for some time, and they are being increasingly refined. But in talking about the utility of these kinds of risk assessment tools, I'm not looking to minimise some of the challenges of them. One of the big challenges with risk assessment tools is that the risk shifts constantly over time. We're talking about dynamic relationships. And risk must be looked at both from the point of view of the risk posed by the perpetrator and the level of risk to the victim. And they're not the same. And one must inform each other, and they both dynamically shift over time. Now, in 2014, the Department of the Attorney-General here in WA asked the Australian Institute of Criminology to consider the issue of how family violence risk assessment tools can be integrated into court-based decision-making. We thought we'd actually go off and get some genuine evidence, which is always good in a public servant. At the outset, my particular view about this issue of courts looking at this risk assessment information is that there are three big issues we should keep in mind. The first is that courts are, of course, constantly in the business of risk assessment. It's part of their inherent discretion of the person on the bench that they're weighing up evidence and issues before them and making professional assessments of that constantly. It's also, to me, it's axiomatic that the better the quality of the information before the court, the better informed is the quality of the decision-making. And as to whether generally it's useful for court decision-makers to have risk assessment tool information before them, given the challenges of ensuring the quality of the risk assessment that is made with the tool, well, I say that courts are constantly in the business of making decisions about how much weight they feel is appropriate to attach to any given piece of information before them. So I think courts are very well placed to be able to look at whatever the risk assessment information that has resulted from the tool and just use that as another piece of evidence before them. Now, the work of the Australian Institute of Criminology on this matter, on how can courts use risk assessment tool information, considered the benefits and limitations of each of the three types of risk assessment. And I note that there's three sort of broad categories of these risk assessment tools. One is unstructured or clinical risk assessments. Another is actuarial assessments, where essentially they run different characteristics through a statistical probability across population type tool. And the other is structured professional judgment on risk. And the AIC work shows that look, there's clearly benefits and limitations to each kind of risk assessment. The AIC also note that risk of reoffending assessments are commonly conducted by correctional services to inform pre-sentence reports to court. So we are using it quite happily in some spaces in the justice system. And in this jurisdiction, we've had some, I think, terrific success with having comprehensive bail risk assessment reports used in some family violence court listing settings. And the sky didn't fall in, I'm pleased to report, but I think courts found out a little bit more about what was actually going on. But while there is internationally some evidence and support for the integration of findings from risk assessment tools to inform decision-makings in criminal courts, the AIC paper does note that you need to be cautious about using these findings. A couple of the warnings that the AIC sound. One, a lot of the tools have been developed in other places, therefore there's issues about validation on the basis of the Australian population characteristics, and also the tools haven't been validated for instance, Aboriginal populations. The Canadian experience in particular tells us if risk assessment tools are being used to inform assessments to courts, then this should be disclosed to the court, so there's a transparency issue with these. However, it was found that one very good Canadian study showed that regarding the use of risk assessment material in pre-sentencing reports, over 2/3 of judges were supportive of having this information available in pre-sentence reports. But interestingly, 40% of judges preferred to see the risk assessment information in a narrative style as opposed to there just being a ranking of high, medium or low risk, for instance. They want to understand what has informed the rating. The Australian Institute of Criminology report also notes, of course, the importance of accuracy of information if the information is going to be put to a court. And they also note that professional development being available to court decision makers so that they understand the tool is of vital importance, and particularly that they understand the limitations of the tool. But also, therefore, the corollary of that is its utility. Now, a couple of observations of my own at this juncture. My strong view is if we're using public resources across government to create this risk assessment information around family violence, and we are, then given the inherent skill, as I've referred to already, of courts being well placed to make judgments about evidence before them, I find it very difficult to understand why we would be doubtful about the utility of risk assessment information being before court decision makers. And this is particularly so because, particularly in civil proceedings and interim civil proceedings, like for an interim violence restraining order, or hopefully soon an interim family violence restraining order, there's still the opportunity to fully ventilate into evidentiary issues down the track. For instance, if somebody wants to contest the making of the order, there can be a full hearing. I just, for the life of me, can't understand why we wouldn't want courts to have full information before them. That is being generated in government through public resources. So hence I'm quite passionate, as you've probably picked up today, about making sure that if we've got this information in government, we find ways to create pathways to get it to decision makers, and these are highly skilled decision makers, and we'll be able to weigh up the quality of that and the weight they should give it accordingly. Now, there might be some conjecture about the use of the information from risk assessment tools going toward courts, I accept that, but there's no argument at all against there being information pathways for risk-relevant information to get before courts. So this is things like domestic violence incident reports of police. We must build these robust information pathways so that if you are a magistrate or a judge looking at either a civil or a criminal issue in relation to family violence, we must have pathways that gets you that highly relevant risk information before you. And this is back to my earlier comment about there's an expectation and a legitimate expectation of the folks out there that when courts are making decisions about these things, that they have the relevant information before them. They should have known. So my view is it's of vital importance that we're working together across government, and particularly between service delivery and the justice space, to integrate to the absolute best extent that we can to ensure that service providers are sharing information between themselves and that there are good pathways to get that information to a court. Now, the new arrangements for the court that I referred to before, for the Magistrates' Court, about dealing with criminal charges resulting from restraining order breaches and serious assaults in family violence setting, have at their core this idea that service delivery practitioners, as they increasingly develop their integration and information sharing over time, can get that risk-relevant information to prosecutors at the court and also to the victim support workers at the court to enhance the risk-relevant information available to the court in its decision-making. And also, as those folks increasingly develop their practice around common basis risk assessment, no reason why that shouldn't get to court too. Now, the courts are doing their part in this model by ensuring that the listing of these various family violence charges are clustered to known days and known lists, so that the service delivery professionals can gather around these lists and do their part. And also we will have victim support workers available at these lists. So as I say, this is a build model, and anybody who's ever had the dubious pleasure of working on any kind of committee with me knows that I say all the time, you can't let the great be the enemy of the good. We must do this work, and there is always in government a worry that if you're innovating, that the potential for risk or a downside means that you shouldn't do it. I don't think that is in any way legitimate. I think what it means is that, as I said before, we have to have terrific governance so we understand what it is that we're doing, and we have to make sure that we put a necessary proportion of our effort, usually in the order of 10 to 15% of the resources in any program, should be focused on evaluation in real time. Anyway, there endeth my lesson about what I think of how we keep progressing in this space of providing protection to victims, and particularly with some of our recent criminal justice initiatives. And so thank you for allowing me to come talk to you about this today. I'd love to come back in 3 years and tell you how we went with all of this. And thank you, Rick.